Good afternoon. Um, so let's get started. Folks will continue to trickle in over the next few minutes. So today, I want to talk mostly about the mental state component of tort liability. And what do we mean by that? What do we mean by the mental state? What do you think I'm referring to when I talk about the mental state? Let me start by asking that. Go ahead, Christianne.
Would that be therefore the motive and their intention, et cetera, et cetera?
Well, yeah, I mean those are examples, but the mental state, right? The mental state of tort liability is what do we have to prove as a plaintiff in order to demonstrate that the defendant deserves to be held liable. Okay, and that's and we're going to talk, over the course of the semester about sort of the details of this. But for today, we're just sort of taking this 30,000 over 30,000 foot overview approach. Okay, and so you guys, in your criminal law class, you talked about the mens rea component of the crime, right? That's what the state has to prove that was the requisite mental state. And there is something similar to that in torts, right? We have to demonstrate that the defendant had the appropriate mental state in mind. And what is that mental state? Well, it depends, right? It depends. For the vast majority of torts, the appropriate mental state that we're looking for is what's called negligence. Negligence, okay? If negligence is the mental state that is in question, then as Rhea argues that intentions matter. In negligence, intentions don't matter, right? Negligence is defined, Cotellini defines negligence as not desiring the consequences of your actions, but being indifferent or careless to those consequences, okay? I think that's a little pretentious in terms of the phrasing, but it gets the job done. It tells you what you need to know. Here's how I would phrase it. Negligence is a situation where you should have known that this could happen. That's it. You should have known that this could happen. Okay. And what that means is that maybe you did know, maybe you didn't. But the plaintiff doesn't have to prove whether you did or you didn't. They just have to prove that you should have known that this could happen. Okay? For some torts, right, for certain classes of torts, we impose a slightly higher, proof standard of recklessness, right? And recklessness, and we're not going to cover any reckless torts in this semester, so this is going to be the only time that we talk about it. In recklessness, right, in reckless torts, the standard is that the defendant didn't care whether these consequences could occur. Okay, so it's not that you didn't know, it's that you didn't care. And what's the difference between those two? The difference between those two is going to come in whether we're proving that it's an objective versus a subjective standard, right? So with negligence, We don't have to prove anything about the particular defendant's stance or knowledge or abilities. We just have to prove that a reasonable person would have foreseen this harm. Okay. For recklessness, we have to go on to show that this defendant, right? This defendant actually just didn't care, right? Didn't have the requisite standard, whatever that is. And then there are even higher levels of mental state for knowledge and intention. Okay, and I want to talk a little bit about intention because I was surprised when I was prepping for this class. In the Caribbean, according to Professor Cotellini, the intent standard in tort liability requires specifically an intent to create the harm that resulted from your action. So it's not enough to actually intentionally do what you did, but you also have to intend the consequences. And the reason that surprised me is that in the United States, where as I said on Monday, I was trained, the requisite intention is not an intention to cause the harm, it's the intention to perform the act. Okay, so let me put this in the chat for you guys, just so that for those of you who are visual learners, so you can have the text in front of you, right? In the Caribbean, the intent in an intentional tort means that the harm was intended. But in the United States, the intent means that the act was intended. Okay, so let me explain the consequences of this, and then we're going to have a little bit of a conversation for a few minutes. What this means is that tort liability in the United States is significantly broader than in the Caribbean. Okay, in the Caribbean, if you bring a tort case, the defendant can just deny that they had any intention to harm you, and then the court has to start inquiring into, sort of the broader circumstances and say, look, what really was going on here? Can we give credit to this testimony that you didn't intend to harm anyone? And those sorts of things. American plaintiffs don't have to prove any of that. American plaintiffs can say, look, when you pick up a sledgehammer and you swing it, you intended to swing the sledgehammer. You didn't accidentally raise it up over your head and bring it down on my car's windshield. So, whether you intended to break the windshield is sort of irrelevant. You intended to swing the hammer, right? So there are trade-offs in this choice, right? What are those trade-offs like? What kinds of trade-offs are being made here? Okay, so I'm gonna just tell you guys, when we're having a class discussion, if you want to use the chat, that's fine, right? I understand that you may have bandwidth issues that make using your audio difficult, but you really need to not do it sending me private messages. We need to be in a position where we can have a conversation as a class. So the person who just sent me a private message, I'm not going to respond to that. You need to make your answers where your classmates can see them. So the question again, right? The question again is, we have these two different conceptions of intention. right? We have the Caribbean conception of the intent to harm. We have the American conception of the intent to act, okay? The question is, what are the trade-offs between these two?
So, sir,
Yeah, go ahead.
this is Rudolph.
Yes.
Are you saying that the act is not as important in the United States, that the intention is not as important as the act in the United States? In other words, usually, as you said, that one looks for an intention to commit some form of act. Basically, like the mens rea and mens rea, and then get actus rea. You're simply saying that they're not that so much interest is not placed on the mens rea, but on the right act. But yet, can there be an act without an intention? In other words, can the act exist in isolation? Can you? Okay, I just walk up to your car and smash the windshield, and you don't really care what I was thinking. The fact that I destroy your windshield, that's what's important to you.
Right. That's it. That's exactly the logic that American courts use, right? Is that, with these acts that we're looking at in the realm of intentional torts, that there's not really a question about the intent to cause harm. We can infer the intent to cause harm from the act itself. So the only question is, did you intend to act? Right? Because the argument is that these are things that by doing them, you cause harm. Okay. And the folks in the chat are absolutely right that plaintiffs have a more difficult time under the Caribbean standard because you do have to inquire into the intent to cause harm. Okay. Now, in practice, right, and we'll learn more about this at the end of the semester when we talk about trespass against the person, when we talk about assault and battery and false imprisonment and those intentional torts. There is a mechanism, right, where Caribbean courts can infer the intent to harm from the broader circumstances, but they do have to go through that inferential step. Whereas in the United States, right, that's the element, right? If you prove the intent to act, you have proven the intent to cause harm. Okay. Yes, and Danielle's absolutely right that there is no prosecution in a tort case, right? The state is not acting as the claimant in these cases. There is a plaintiff who is the wronged party. Okay. No big deal. This was, just a minor thing. So this is the trade-off, right? Is that in the Caribbean, plaintiffs have an extra step that they have to prove. Okay. Doesn't necessarily mean that when we look at the patterns of cases that there's going to be a difference in outcomes, but it does mean that Caribbean plaintiffs have to take that extra step. Okay. So here's the next question. Which of these is the better approach? And I'm going to go ahead and warn you that the question after that is why. So be thinking about that as well.
All right, sir.
Yes, go ahead, Rudolph.
January 6th, we saw what people did to the United States Capitol and how they caused extensive damage there. And we're looking at, from the American perspective, you're looking at the acts. They're not interested so much, even though eventually they will invest the way. They are concerned that you trespass, again, that's a tort. You did this, so there were several torts there, but they come down to the acts. The act of trespass, because you actually went there, the act of sending the speaker's chair, the act of destroying that, stealing, those are acts. I agree with that. I agree with that simply because a person may have an intention to do something, but may not commit it. And in isolation, you cannot judge a man for thinking of doing something wrong. Like I said earlier in my example, I feel like looking up your windscreen, but then I didn't do it. But for the very fact that I committed it, they're not necessarily, you're not really caring about the intention. So when these people stormed onto the Capitol and did what they did on January 6th, I see from my way would be that it puts the person in a better position to judge the action. And it is the action for which the tortious liability is found.
Well, let me just sort of clarify one thing that I don't think you're mistaken about, but I want to make sure that we're clear with it, for the rest of the class, is that torts, we don't police people's thoughts in tort liability, right? As Rudolph points out, there actually does, regardless of the standard of intent, you do have to have the actual act, right? If you don't have the act that creates the harm, but you just have the requisite intent, as Rudolph points out, if I intend to smash up your windshield, but I never actually do it, well, okay, we can go tisk tisk. You shouldn't think that, but nobody's gonna arrest me or sue me for thinking, man, I'd really like to take a sledgehammer to that car. So there absolutely has to be the act involved as well. But Rudolph is raising a really interesting point, right? And I see you guys in the chat, and we're going to talk through what you guys have offered up in a minute, right? So these knuckleheads who stormed the Capitol in my country a couple of weeks ago, right? They thought that they were saving the country, right? That they were preventing a secret deep state coup, right? Because they'd been lied to for 2 months. And so arguably, right, if they had just, broken into the Capitol, no damage, no assaults, no harm to anyone, they just sort of wander around. Some of the pictures that we saw were of people, it looked like they were like giving themselves tours, right? So if everything's like that and there's no harm to anyone and nobody gets hurt and there's no worry that anyone's going to be assassinated on TikTok, right? Then arguably, under the Caribbean standard, none of those people have committed torts, right? Because there's no intent to cause harm. Under the American standard, they did, because they intended to go where they weren't allowed. Okay, so that's the difference in the standard. So with that, let me work through the chat here. So I'm seeing a lot of folks, sort of saying, look, look, the purpose is to punish, right? Some folks are saying, if you didn't mean to do anything wrong, why should you be punished? And I think that this is sort of the fundamental question of tort, right? That we talked about on Monday, is who pays for the harm that results from mistakes. Okay. And in intentional torts, it's not a mistake, right? The question is, are we going to automatically infer the intent to harm from the intent to act itself? Okay, so going back to the insurrectionists, right? Or the peaceful insurrectionists who are fictional, right? These peaceful rioters that I'm pretending are out there. Can we infer from the fact that they stepped onto the Capitol property that they intended to harm people? And okay, do you pronounce your name T or Ty?
Tia.
I'm sorry.
It's Tia.
Tia. I apologize. So why do you say that no, we can't infer that they intended to commit harm from the fact that they committed this tort of trespass, right? Laying aside any criminal issues, we're just interested in the trespass. Why do you say no?
I was thinking if they entered lawfully, but since you said that they trespassed, then maybe yes. Sorry about that.
Okay, well, that's fine. That's fine. So, Tasma, you said no as well. Why do you think we can't infer that? Hello, are you there? Oh, okay. We'll move on. Tamera, you said no. What can you?
Tamera, but I was going based off.
Tamera, I apologize. Go ahead. Thank you.
I was going based off of the same line as Tia, because if they were there lawfully, you just can't look at somebody and say, well, they intend to commit a crime.
Fair enough. Fair enough. And I think that's right. Right. If they had been lawfully in the Capitol, right, not a situation where they were there unlawfully, but they didn't do anything except sort of wander around, then that creates a different hypothetical, right? I agree with that analysis. So, so you guys that are saying yes, what are your thoughts? Carla Ray, you were the first one to chime in. So what do you? Okay.
Yes, sir. Trespassing is wrong. So you can't predict, like I said earlier, what the consequences will be. Because if you trespass, you don't know what the persons that are charged with keeping the law, the peace, and the order will do. And given those circumstances, you may retaliate. And then, like what happened, and as a result, people died, people were seriously injured on both sides. So I would say that, yes, you can infer that a tort will be committed.
Okay, so you're thinking that maybe the American rule for intention makes more sense in this particular consequence. Okay.
No, generally, that's why
Okay.
many criminals, in my opinion, get off, because this burden of proof that the prosecutors have to prove it, it creates, to me, a lot of injustice, because once you can't have a sledgehammer. No good comes from a sledgehammer. You swinging it. There are only, whether you intend, there's nothing positive, that there's no positive outcome. Whether people get hurt, you can't say, oh, I didn't intend for something bad to happen, because nothing good can happen.
Yeah, and certainly the details of how Caribbean courts sort of go from the act and the broader circumstances to concluding that that in fact you did intend the harm that you caused, even over the defendant's denial, right? Those are going to be things that we'll look at a little bit this semester, like I said, when we talk about the trespass against the person torts, but you'll look a lot more at them when you take torts too, because that class covers a lot more of intentional torts. I'm sorry, Michael, you've had your hand up very patiently. I apologize. Go ahead.
I have a bit of a different question.
Sure.
I'm trying to figure out whether it is necessary to establish, for example, trespassing being unlawful or whatever. And this is coming from the worksheet 1, where the first question that you asked was, if Mark steps on King's foot while trying to go to the bar at a crowded line, can tort be established? And I was saying, well, it is not unlawful, but if the idea of tort is to compensate because the person's standard of living has been altered, then does it really matter the reason why the person did what they did? Let's say he stepped on Kim's foot and Kim lost all use of her foot for the rest of her life. Suppose he did not intend it because the bar was lying, the line was dark, sorry, and he genuinely could not see what he was doing, but that happened. So what in that sense?
Yeah. So this is going to be something that we talk about a little bit more in a couple of weeks, but these are going to be situations where the question becomes, what duty did the defendant owe, right? So how much care did, I'm sorry, I missed the name of the person who stepped on the foot.
Mark.
Say, I'm sorry?
Mark.
So you know, how much care does Mark have to take in terms of looking out to make sure that he doesn't step on anyone? And did he take that care, right? Did he make sure that, did he do what was necessary, whatever that is? The other thing is, you know, maybe it's possible that the duty of care, lies with the bar owner, right? Maybe the bar owner had a duty to provide more light in the environment, and that's where the breach of the duty lies. You know, these are all just spitballing, right? We'll talk about these in more detail over the next couple of weeks as we talk about the duty of care and the and how to prove a breach. But those are the kinds of things that you're looking for when you when you're asking, is a tort established? You're asking, the way to think about a tort, a question regarding tort liability is, what about this situation would have to change for the harm to not occur? Okay, so that, you know, what would have to change for the harm to not occur, and who would be responsible for making those changes? Okay, and if you can point to a person who could change the situation so that the harm never happened, and it's reasonable for those changes to have happened, then that's going to be a strong argument for tort liability. So does that make sense, Michael?
Yes, it does. Thank you.
Great. So what other questions do we have? Both about, you know, intent, both about negligence, and or, you know, just sort of broadly about the material in the first worksheet. Not responding to private chat messages. Tia, what do you mean by breaking the chain of causation?
When you were talking about what Michael was asking about, who to blame, what circumstances would have changed it if it had not been for that person's actions? Is that what you're talking about? Like, kind of like that?
To some extent, right? So certainly there will be an issue where we can raise, well, look, you know, the change that you're asking for is so remote that it can't possibly have made a difference, right? So these are situations where something else has happened to cause the harm. Okay, and we'll talk more about those when we talk about causation and remoteness in a few weeks, but that's certainly a possibility. But while we're on the topic, Keandre, I see your question, but since Danielle has jumped in on this, I'll let her make her point, and then we'll come back to your question. Okay, so Danielle, go ahead.
Hi, afternoon. Just in regards to what was previously said, because the primary factors limiting compensatory damages have been outlined by the law as per previous cases, we know that those are causation, remoteness, and mitigation. And causation just deals with whether or not the defendant had legally caused the action. And so in the American standard of proof, the mere act or omission would be enough of a standard of proof to say that regardless of whether or not you intended the injury or damage to occur, the fact that it occurred means that you are liable. And so the question is, but for the particular act or omission that this person did, would the injury have arisen when and how it did? And in regards to remoteness, which is proved by the foreseeability test that was put down in Wagon Mound, merely to say that the defendant would be liable because they would have reasonably foreseen general damage occurring as a result of their act. And so regardless of the specific sequence of events which occurred, the fact that a general damage could have been foreseen would make them liable.
So everything that you've said is correct insofar as I'm aware, but there's some things that are a little bit muddy in your comments that I just want to clarify a little bit. The first thing is that, you know, the intent to act, right? That specifically refers to the intentional tort standard. And the question of causation and remoteness relates to negligence, right? So in intentional torts, those aren't issues because the intent element sort of consumes the causation question, right? If you meet the intention element, then we can presume that causation is there. Okay, so you're absolutely right. Everything that you said about causation and remoteness and about the intent, the consequences of the intent to act, but it is these are two different classes of torts, right? And the intent to act does not come into play in negligence cases. And similarly, the causation and remoteness analysis does not come into play in intentional torts. Okay, so that's the only thing that I wanted to clarify there. But other than that, everything's spot on. Really great stuff. I'm very glad that you're very clearly reading ahead. So thank you so much.
Also, just because you said that, sir, I remembered that there is an exception to the principle of remoteness, which would be Smith v. Leachbrain. Yes, still negligence, but just the fact that well, I'm not sure if you could apply it for specific intent, but the thin skull principle, and Lord Parker had held that because the egg skull rule and taking the victim as you find them are principles that have always been established in law, it's not affected by the rulings of Wagon Mound, which means that there is you don't have to prove foreseeability.
Yeah, no, that seems right to me, that those components play into that in that way. But again, it doesn't seem to me to have anything to do with the intention question, right? The intention question, I think, sort of, like I said, consumes all of that analysis and just says, here endeth the inquiry, you intended this, and so you're going to have the consequences. So okay.
Sir.
Yes, go ahead, Rudolph.
Now, tort has two elements. One is a duty owed, And secondly, is that duty breach. So first of all, is there a duty of care owed to the person who got hurt? And secondly, was that duty breach? So what we learned as again, as I was reading, I discovered that a duty is owed by everybody to the other person. In other words, you owe a certain duty of care not to cause harm to that person. It also suggests that harm is caused because there was a breach of failure and you're carrying out that duty or exercising that duty towards that person. So again, when I look at the act, I see this act being caused on another person in turn is due because there was a breach of your duty to that person. Let's use Michael's example. Michael said he goes into, you're in a club or someplace and Mark steps on your foot and causes extensive damage to that person. Again, as you said, a duty of care is owed to the person in there. So Mark ought to take a certain duty of care to ensure that he does not step on a person's foot in such a manner as to cause extensive damage. Now he would have only have caused that extensive damage if he fails or breaches that duty. You also alluded to the fact that perhaps because of the lighting or so, some other circumstance that may have caused that. But again, as you said, again, there is the duty of care owed to the owed by the proprietor of the place. And if he fails to have proper lighting, now that is where he breached. So at that breach, and it seems to me that the breach is the thing that causes the harm. It leads to the harm.
Right. But there are certainly, right, there are situations where the breach of the duty is not the most proximate cause, right? There may be situations where there are superseding causes, there may be intervening causes, there may be joint causes, just depending on the facts of the case. And we'll talk about those doctrines in more detail when we talk about causation in a few weeks. But yeah, there's absolutely, right, the absent some other fact, right, the existence of a breach of a duty of care and the existence of harm creates a causal link. Okay, now as a social scientist, that's a statement that makes my antennae twitch, but as a lawyer, that's the way that we operate. Okay, is that we have the breach of the duty, we have the harm, unless there's something in the middle that gives us pause, we infer cause and effect here. Okay, so all right, I want to move on from this because there are some other questions in the chat that I want to make sure that we get to. So Keandre asks, doesn't mental capacity play a role? And the truth of the matter is that there are cases where that's true, but for the most part, in most negligence cases, you as a defendant are being measured up against the reasonable person, whatever that means.
Reasonable man.
Well, it's 2021, so it's a reasonable person. So the standard is objective. And there's actually some cases, if you go and you look, if you have purchased the Elliott and Quinn textbook, which is not required, but it is the sort of second book that I'm using to sort of help me prepare in this class. But if you go and look at it, you'll find that there are cases where student drivers who are taking driving school and they're on the road with a teacher in the passenger seat. I'm gesturing to my right because I learned to drive in the United States with someone sitting to my right. But you have a teacher sitting in the passenger seat. And they get in a wreck. And the courts held that these student drivers who don't even have enough experience to be licensed to drive are held to the same standard, of care and the same responsibility as experienced drivers who have decades on the road. Okay, so mental capacity can play a role in certain cases, but for the vast majority of negligence cases, mental capacity of the defendant simply doesn't matter, right? They're held to an objective, reasonable person standard. Okay, so Shasha asks, is a person's liability determined or level of liability be higher or lower based on if the plaintiff can prove they were negligent or had the intention or are both considered? And the answer to that, and I may have mispronounced your name, so feel free to jump in and correct me on that. I'm sorry, you unmuted.
It's Shasia.
Sasia?
Shasia.
Shasia. Okay, I apologize. And
It's
let me just say this to all of you and to Shasia. I've said this in tutorials so far, and but I'm going to say it to you guys now, and I'm going to say it again in the tutorials on Thursday and Friday. You're entitled to have your name pronounced correctly. So if I pronounce it incorrectly, please correct me. Please tell me the right way to pronounce your name, because you deserve to be called by your actual name, not by some other series of sounds. I can't promise that I'm going to get it right the first time or even the second time, but I promise that I'm going to keep trying. Okay. So to come back to Shasia's question, the answer is that there are certain types of torts where negligence opens the door to certain remedies, right? But a higher level of culpability, like intention or recklessness, can open the door to other kinds of remedies. To be perfectly frank, I don't know off the top of my head how available punitive damages are in the Caribbean. But in general, if you can show intention or recklessness in the United States, that can open the door to a punitive damages award above and beyond what's necessary to, as we discussed on Monday, right, make the plaintiff whole, right? There can be a deterrent award of punitive damages. So I know that punitive damages are available in the Caribbean under certain circumstances, because I know it's in the textbook as something that gets covered. I just don't know the details of sort of what you have to do to prove an entitlement to them. Okay. Last thing. Okay, there's a question in the chat, and then I'll move on to the last thing. Danielle asks, similar to how mitigation would limit liability for negligence, would it limit specific intent cases as well? Because the standard of proof in tort is on a balance of probability. Therefore, if the plaintiff can prove that the injury they suffered could not have been reasonably avoided by their own act or omissions, then the intent of the defendant wouldn't be the primary determining factor. I would tend to probably agree with that, but mitigation is a question of damages, right? So mitigation doesn't affect the question of whether the defendant is liable. It affects the question of how much of the plaintiff's damages they're responsible for. So I think that you're right that mitigation can play a role here, even in intentional torts, but I don't think that it affects the question of liability. Okay. Barry asks, what determines the application of tort law in court in the Caribbean, and why are we so focused on American law? I'm going to answer these out of order. We're talking about American law a little bit by way of comparison, right? To let us, and also because, frankly, your classmates are asking questions that are a little broader than what I've prepared. And like I said on Monday, when you do that, when you ask me questions about material, about issues that I'm not prepared to discuss, I'm happy to discuss them if because that's what you're interested in, but I'm going to discuss them using my own experience and my own sort of pre-existing knowledge, which is overwhelmingly American. We are not going to be spending the entire semester talking about American law. We are going to be focused on Caribbean law in this semester. But today has been a little bit of an outlier. But I respect that as that's a serious question. That's a legitimate question. You are not here to learn American law. I am not here to teach it. Okay. So I appreciate you bringing that up. The answer to your first question, I'm not entirely sure what you're asking. I guess the answer to your question is the application of tort law in the Caribbean is determined by the filing of a tort case, right? If you file a tort, then tort law applies. You know, I'm not sure. I guess I don't have a better question. Okay, I apologize. All right, one last thing, and then I'm gonna let you guys go for the day, and that's that there is a third class of torts where we're not concerned with the mental state of the defendant at all. Okay, these are called strict liability torts. Okay, and they're relatively uncommon, but basically they're situations where the harm is so grievous and is so certain from the harm is so certain and so grievous that engaging in this act is a per se tort. Okay. So one possibility, right? Slander per se is a strict liability tort. And basically it's a particular class of slander that where you say certain types of false things about the plaintiff. And the idea is that these categories of things, and we're not going to cover it in any detail this semester, but these categories of things are so bad that just saying them is enough to create liability because you've already harmed the person just by saying it. You don't have to show any damages. If you show that it was uttered, you win. Okay. You also see strict liability in a lot of like hazardous materials torts. So for example, if a truck spills a hazardous chemical, in the road, there's going to be strict liability for that. We're not going to ask the question of, was the driver negligent or was it negligently stored? Go ahead, Michael. Oh, okay. So those are sort of strict liability types of torts. Okay. So we are out of time. I really appreciate you guys being engaged and being prepared. This was really fantastic. I really appreciate that. I also want to say that I appreciate Barry keeping us focused and on task and making sure that we're committed to learning regional law. Okay. I don't want to go down a rabbit hole with you guys and teach you guys a bunch of irrelevant stuff that you don't need. So I appreciate that as well. And with that, I'm going to let you guys go. And I will see those of you that I've not seen in tutorials. I will see you guys on Thursday and Friday. The rest of you, I'll see you guys on Monday. So take care. And
excuse me, Dr.
Yes,
Krell,
go ahead. Go ahead, Joy. I'm
Thursday's
sorry. Go
what
ahead.
if there's a holiday in Barbados?
I'm sorry.
Thursday is a holiday in Barbados.
Tomorrow is delayed.
Tomorrow is
Bar's birthday celebration.
Oh, well, I mean, well, look, tutorials this week are not by any stretch of the imagination mandatory. You are not covering anything. We're not covering anything that's course material. Like I said on Monday, it's just going to be you guys getting to know me getting to know you. Like that's all that's happening. So I will be in Zoom for the tutorials tomorrow. If you guys choose not to come, you will not hurt my feelings. Okay. Rhea has a quick question. This is going to be you're going to get the last word. So.
Yeah. Sir, one of your tutorial, your worksheet questions asks if Giselle shoots her enemy Jackie during a confrontation, can a tort be established?
Okay.
When I read that, I immediately thought that the action was criminal. So I was wondering why is it here? Like whole self.
So the answer is that there are things that are both, right? There's absolutely both criminal liability and tort liability, and because the standards of proof are different, right? They can be separate proceedings. Now, your tort case will not proceed until the criminal case is over and done. Okay. But just because the defendant is acquitted of the crime does not mean that they cannot be held liable in tort, because the standards of proof are different. Okay. So absolutely, you're absolutely right that that's a fact pattern that describes a crime, but it may also describe a tort. Okay. And so that's a legitimate question, but that's the answer, is that for those sorts of activities, there's absolutely both criminal and tort liability. Okay. All right. So I appreciate you guys staying late. Celeste, you're absolutely right. I was not going to mention the OJ case because it's an American case, but you're absolutely right. But yes. So again, I appreciate you guys staying late with me. I really do try and get you guys out of here right at the end of our session, but this going over was perfectly fine. And I will see you guys later. Again, tutorials this week are optional, especially tomorrow, but certainly I'd love to see all of your smiling faces. So take care, and I'll see you guys later. So,
Sir, can I
Yes.
ask a question?
Go ahead.
When you were studying law, did you perceive yourself teaching in Barbados?
No.
Thank you. That's just my question.
This was not what I expected, but I'm glad that I'm here. So I'll see you guys. I'll see you guys later. So take care and bye.